Hello, my name is Howard Kline, and I'm a trademark attorney at Nath, Goldberg & Meyer. Today we're going to be discussing how to best prevent your trademark from becoming generic. This is a good problem to have in that you have a trademark that you file with the USPTO or that you just use in common law that becomes so popular in the marketplace that it is on its way to becoming a generic term. That, as a trademark owner, is a bad thing because once it becomes a generic term, it's very difficult to enforce that trademark right, and you may actually be at risk of having your trademark canceled at the USPTO. We are now in the week before the Super Bowl 59, and everyone is talking about whether the Kansas City Chiefs will three-peat. One problem there, Pat Riley and his company filed trademark applications for three-peat. In the 1980s, he was the coach, Pat Riley, of the Los Angeles Lakers, and he was on his way to potentially winning a third championship when they coined that term. They filed this application for three-peat, one word, the number three-peat, and three with a dash peat for a variety of goods such as clothing, collectible items. And the question becomes, how does Pat Riley's company really enforce that trademark when it's being used everywhere in the week before the Super Bowl? And there are many ways. First, the easiest way is to file the application with the USPTO. That effectively prevents third parties from securing valuable trademark rights by securing a trademark registration. Importantly, merely filing a trademark application doesn't prevent other parties from using a trademark, a confusingly similar trademark, in commerce. So then it becomes your right, your obligation as a trademark owner to enforce those trademark rights. Do you need to enforce it against every third party? No, you do not. But what are some ways and best strategies to go ahead and enforcing your trademark to prevent your valuable brand from becoming generic? First, cease and desist letters. You send cease and desist letters to the most egregious users, big corporations, entities that are really clearly using your brand in a nefarious manner. Once you send that cease and desist letter, the question becomes, do you then file a trademark infringement action in federal court? Or if they filed a trademark application with the USPTO and it gets approved for publication, do you file a cancellation or opposition proceeding at the Trademark Trial and Appeal Board? Those are both excellent avenues to enforce your valuable rights. Second, Amazon. Amazon sells a wide variety of goods, and they have something called the Amazon Brand Registry. It is critically important as the owner of a trademark registration for goods to register your brand with the Amazon Brand Registry. That provides you an easy avenue to take down third-party uses that are infringing. And you can do the same on other platforms as well. Once again, if your trademark, it becomes incredibly popular in the marketplace, that's generally a good thing for you and your company, but you do have an obligation to enforce those rights. Because if everyone starts calling starts using three-peat in the marketplace, it's impossible to know who the brand owner is. And Pat Riley's company has an obligation to enforce that right and to prevent other parties from using it in commerce. If you have any questions about the best manners of filing applications, securing registrations, and then enforcing those trademark rights, please give us a call. We can be reached at 703-548-6284. Alternatively, we can be reached at ip@nathlaw.com.